for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the incredible William Porter, a California construction lien law guru. Today's webinar topic is getting paid faster. Today's webinar topic is Lien and Bond Claim Masterclass, everything they don't tell you but should. So without further ado, I'd like to introduce the wonderful and incredible William Porter.
Thank you, Jessie, for that really nice introduction there. I appreciate it greatly. I think you exaggerated a little bit, but we'll just go with it. Okay, anyway, I want to say something about the title, Everything They Don't Tell You But Should. That I would say that the things that they don't tell you is because there's no one out there telling you. We're telling you now, and so that's good. But most of the things that they don't tell you is the importance and the need and the prerequisite nature of a preliminary notice, and also all of the very important deadlines, which if you miss, you lose your rights to a mechanics lien, a stop notice, and a bond claim. So I'm going to go through all these. I'm going to go kind of quickly, but you have the written materials, and I'll say right off at the very beginning that if anybody has any questions, my number and my email is there. You can always reach out to me if there's something that you don't understand. Okay? Anyway, without further ado, why don't we go to the next slide? There you go for answering or for asking questions. You can see the instructions, and then towards the end of the seminar, if you have any questions, Jessie will ask them of me, and then I'll help to answer them. Next. Okay, it's a legal disclaimer. There are exceptions to all the rules that I'm going to discuss today and distinctions. We can't go into every one of them because we're going to try to fit this into 20, 25 minutes like that. But if you find something that you don't quite understand, I'm here in California. I think all of you are in California today, and so you could give me a call at the number on the earlier slide. Thanks. Next. Okay, the main things that we're going to discuss, among the things they don't tell you, the preliminary notice, usually a prerequisite to the three things that follow, which are the mechanics lien, which gives you an interest in the property. So if you don't get paid, you can get sold, you can have the property sold and then get paid from the proceeds. The stop payment notice, which causes the owner of the property or a bank to hold money for you to the extent that you're a subcontractor or a supplier, and they'll have to hold the money for you so it doesn't get to the GC and get spent. And then the payment bond claim, which is a company that provides a bond so that if you don't get paid by the owner or a GC or a higher level subcontractor perhaps, then the bond will pay you. These are our subjects. Okay, next. Okay, let's talk about the preliminary notice. Okay, the preliminary notice is something that you have to send out within 20 days after supplying work or materials to a project. It's a prerequisite to a lien and a private on a private works project, and also to bond claims. So going into the details here, and you can come back to these because I'm going to have to be going fast. It's this prerequisite, and the rule is, which they don't tell you, that subcontractors and material suppliers on a private project are required to serve the preliminary notice on the owner, the direct contractor, and the construction lender to the extent that there is one. Here's the code sections. You could look up those code sections to get greater details on all of these things. So if you don't do the preliminary notice, and this is the main thing, you have no right to a mechanics lien, a stop payment notice, or possibly a payment bond claim on a private works project. Okay, direct contractors, here's a rule, important rule. Direct contractors, that's who has a contract with the owner, are not required to serve a preliminary notice on the owner in order to pursue a lien against the owner. However, if there's a construction lender on the project, and that means a lender for construction purposes, not just a mortgage lender from years before, but an actual construction lender with a recorded, let's say, construction loan deed of trust recorded at the county recorder. If this is the case, then the direct contractor does have to serve the preliminary notice on the construction lender. And then on public works, it's always the case that the direct or the prime contractor and first tier subs don't need to serve a preliminary notice. That's for public works, okay? Private is a little bit different, as I discussed earlier. For those required to serve the preliminary notice, the notice must be within 20 days after first furnishing your labor, materials, or equipment to the job site. You can send it earlier, so maybe right after you have the contract in place, then send out the preliminary notice. Just don't send it any later than 20 days after you begin work. So have an established procedure in your office to make sure that a deadline is never missed, okay? Oh, I just lost my, I just lost this.
Are you saying that you just don't have the visual of the slide?
I don't have the visual on my screen anymore. Hold on a sec. Okay,
Yeah,
it's back.
it's still up for our viewers. There you go.
Yeah,
it's
good.
okay, no worries.
Okay, anyway, you're going to want to send out this preliminary notice by registered mail, certified mail, return receipt requested, express mail, or overnight delivery by an express carrier like FedEx or UPS or something like that. Now you can serve it by hand if you want, but think of it, I mean, it's legal to serve it by hand, but then you won't be able to prove that you served it. So I would suggest the best is probably certified mail, return receipt requested. Always make a copy of the notice for your records. Yet when you send it out, you will get a signed version of it back, and then you're going to want to save that. Now, if you have properly addressed things in sending out the preliminary notice, and the people on the other side decide they don't want to sign for it because sometimes good things don't come by certified mail and people don't want to sign, that's okay. It's not necessary that they sign as long as you properly sent it out to the proper address and then it comes back unaccepted, but it was the proper address, then you should be fine, okay? And then as noted earlier, the failure to serve the notice when it's required is going to invalidate your claim of mechanics lien and a stop payment notice and a payment bond claim. If you're late serving it, it will be effective going back from the date you put in the mail, going back 20 days. Okay, and then it'll be good after that, but it's best not to be late serving it at all so you don't have to worry about that issue. Okay, next. Okay, let's talk about the mechanics lien. So if you did the preliminary notice right, then this is the thing that you're going to do after you have not been paid in full after completing your work or supplying materials to a project. Okay, now a lien is not available on public works projects. It's an extremely a valuable remedy, because what it allows you to do is sell the property where the work was performed and then get paid from that. So even if you don't have a contract with the owner of the property, you're a huge threat to the owner. So the mechanics lien will cause the owner to go to the GC, who may cause the GC to go to the sub and say, hey, fix this, because the owner does not want their property sold. So even if you have no contract at all with the owner, you can get to the owner through a mechanics lien. And honestly, if you have a good mechanics lien, your chances of getting paid are hugely assured. You know, even if the owner of the property goes bankrupt, you will be a secured claimant in the bankruptcy if you have a valid mechanics lien. And as a secured claimant, you get paid in full before the unsecured claimants get a penny. Okay, so it is a very, very valuable remedy. And I think I've discussed most of the things here. You can see the statute down there where you can look it up if you need more information. But unless you have a contract with the owner, don't forget the preliminary notice is a prerequisite. Okay, and even if you're a GC, if there's a construction lender, you still need to do the preliminary notice in order to have a mechanics lien. Okay, next. Okay, for the direct contractor, if there's a valid notice of completion or notice of cessation recorded on the property in the county where the work is physically located, then the direct contractor has 60 days after a notice of completion to record their mechanics lien. So that is something they don't tell you. That is a very important deadline. Okay, and note this. This is interesting here. A notice of completion is only valid if it's recorded within 15 days after actual completion of the work of improvement. Not just your work, but the entire work of improvement. And there's another thing called a notice of cessation, which means the project stops. It's the same thing as a notice of completion legally, but it can only be recorded on the property after the work of improvement has stopped for a continuous period of 30 days with nobody working on it. So if someone says to you, oh, hey, you can't record a mechanics lien on the property because there was a notice of completion or a notice of cessation more than 60 days ago, then you really can't go on that information because you don't know if that recorded notice of completion is valid, because it can only be recorded within 15 days after actual completion, and similar with a notice of cessation, which has to be after no work on the project by anybody for 30 continuous days. So you never know if a notice of completion is valid or not. I would say the best thing to do is probably just go ahead and record the mechanics lien. If you were late, then it'll be determined. But if you hesitate because someone told you not to record because you might be late, then you'll be making a mistake. It's best to just record it. And subs and suppliers down here at the bottom of the page, it's a little bit different with them with prime contractors. Subs and suppliers generally have as few as 30 days after the date of the notice of completion or notice of cessation before subs and suppliers have to record their mechanics lien. Now, you don't have to get close to the 30 days, nor with the GC the 60 days. As long as you are done with your work and you're not paid, you can go ahead and record your notice, or I'm sorry, record your mechanics lien. Okay, next slide. Okay, now sometimes there is no notice of completion or notice of cessation. If there is no notice of completion or notice of cessation, which has been recorded, then generally everyone, GC, subcontractor, suppliers, everyone is going to have 90 days after actual completion of the project before they have to record a mechanics lien. Now, you don't have to wait for the 90 days, just like you didn't have to wait for the 30 or 60 days if there was a notice of completion. You don't have to get close to that 90 days. If you are done with your work and you're concerned about the 90 days is getting too close, you probably want to go out and record your mechanics lien. How do you know, though, if the project has been actually completed? Sometimes you can tell because, let's say it's a restaurant and they have their grand opening. So at least by then it's been completed. Okay, probably a little bit earlier. But in order to determine when there has been completion, you look at this A, B, and C here on the screen, and you pick the earliest of those. So A is if there's actual completion, and you know, beyond a doubt, everything is done. Okay, if you're able to determine that, then that would start the 90 days ticking before you have to record your lien. Or another method is the work stops and the owner or the owner's agent occupies the work of improvement. So you've done a, let's say, a tenant improvement on a business, and then they move into the offices that you created in the building. Then that would be the beginning of the 90 days. Or there's a cessation of labor. Nobody's working on the project for a continuous period of 60 days. Now you look at the A, B, and C, and you pick the earliest of those, and then from that point of the earliest, you have 90 days to record your mechanics lien. But again, like with the other deadlines, there's no point in getting too close to the 90 days because you might miss it because you're unaware of something. And so I would say that if you get to the point where you're done and you're not getting paid, probably just record your lien. Besides, when you record your lien, you have 90 more days to file a lawsuit. So hopefully you can get things worked out within that time period and then release your lien. Once the check clears, always the check has to clear before you would release your lien. Okay, next slide. Okay, the procedure to record a mechanics lien, it's pretty easy. You take it to the county recorder in the county where the property is located. There's going to be a filing fee. You always want to bring an extra copy with you, and then you pay the fee. They record it, and then what they do is they will send it back to you in the mail with a stamp on the upper right corner of the date of recording. Okay, then the important thing to do at that point, when you get it back from the county recorder's office, is that whatever date they recorded it, which is on the upper right of the mechanics lien when they send it back to you, you're going to have 90 days to file your lawsuit. And that is a great time period to start talking to the other parties and saying, hey, look, I would like to get this resolved. If I don't get it resolved, I'm going to file a lawsuit, and then we're all going to be in a lawsuit, and we'll have to fight this out. Honestly, rather than going into a lawsuit too, if you could see through to compromise a bit. Let's say you have a $100,000 lien, and the owner offers to pay you 90 right now, rather than going into litigation and all that. Well, then you say, I'll take 95, whatever. Just, it is better to compromise a little bit than go down the path of a lawsuit and pay attorneys and have a year or more of frustration and mounting attorney fees and all that. So work it out if you can. Get your payment if you can. Don't release your lien until the payment clears the bank. Okay? And then you can do a release of Mechanics Lien. And by the way, all these things that I am talking about are things that SunRay can do for you. They can do the preliminary notice, they can do the Mechanics Lien, they can do the stop payment notice and the payment bond claim. So you can rely on them for getting these things done. But my point is to tell you some of the things that people don't tell you. Yeah, you got to do these things, and you got to watch your timelines. Okay, and so other than that, these are important things you need to know. You would come to someone like SunRay, or ultimately someone like myself, if you wanted to go forward with a lawsuit, which I would say avoid them when you can. Okay, I kind of got off track. Next slide. Okay, and then the lawsuit deadline, I just spoke about it. Once you record the lien, you have 90 days to file a lawsuit. In that lawsuit, there's going to be other things. Of course, there's going to be a breach of contract, because you not getting paid is a breach of contract. There's going to be foreclosure of the lien. If you also have a claim on a payment bond or a stop payment notice, they're all going to be in the lawsuit. Every potential claim is in there. And then even though you have a Mechanics Lien claim and a stop payment notice claim and a payment bond claim, which just makes your position very powerful, it doesn't mean you're going to collect the same amount 3 times. So ultimately, you'll get paid, most likely, if everything that you say is true and you deserve to get paid and there weren't legitimate back charges against you and that type of thing. But you will collect once, and you may collect attorney fees too, depending on things. There could be prompt payment remedies. There could be an attorney fee clause in your contract. And so that would be nice to get all the money that you're owed, your attorney fees, maybe some interest. And if there's prompt payment remedies in California, which are wonderful too, they can give you interest up to like 24% and maybe more. Okay, but that's another topic. Okay, next slide. Okay, the stop payment notice. Okay, the primary purpose of a stop payment notice, and it's another form that you could serve, and that is something that SunRay can do for you, is you get the one holding construction funds to set aside money so that you can be paid. So if you're owed $50,000, you would do a $50,000 stop payment notice. Then the owner, or perhaps the lender, would be required to withhold that $50,000, then maybe an additional 25 to 50% more to make sure that you get paid. This is what they typically do. Private work stop payment notices are served on the owner or the owner's architect, if there is one. And if it's a bank, it's going to be at the responsible officer or a person at the branch of that lender in charge of the construction funds. The time period within which you have to give a stop payment notice on a private project are the same as those for recording Mechanics Lien, basically. And then there's the code sections. You can look them up. If you're going to do something like, it's hard for me to see. There's something covering up my language here. Someone like Caltrans, then you're going to do on the auditor, or I should say dispersing officer of the department issuing the original contract, like for Public Works. Okay. The stop payment notice can be used in conjunction with the lien and the payment bond claim, and so you could do all 3 of them. You don't have to pick and choose between the 3 remedies. To the extent you have them, use them and make a claim on all 3 of them. Who knows? Maybe you made a mistake somewhere along the lines on the Mechanics Lien or the payment bond claim. Then you have the stop payment notice claim. So in case you made a mistake on one, you'll have one of the other ones. All right, next. Okay, bonded stop payment notice or not. So the basic rule is that generally on a private project, if there's no construction lender, you don't have to do a bonded stop payment notice. But this is a thing that people, it's like one of those things that nobody tells you. If there is a construction lender, then you're going to have to do a bonded stop payment notice if you want the construction lender to pay attention to you. Because unless your stop payment notice is bonded, then the construction lender is not going to do anything. They're not going to withhold funds, and they're not going to tell you. They're not going to say, oh, hey, get a bond for your stop payment notice, because ultimately they don't want to pay you anything. They will just ignore you, and then when you come to file a lawsuit, it will be unsuccessful as far as the stop payment notice is concerned. So it's just the rule that if it's a private works project and there's a construction lender, then you are going to want to do a bonded stop payment notice. Okay, now that's private works, because of course there is no construction lender on public works. We, the taxpayers, are basically the construction lender, with our governments running in deficits all the time, but that's another story. Anyway, though, with public works, you do not have to have a bond on your stop payment notice, and it'll be just fine. Okay, next. Okay, to give a stop payment notice, you're going to fill out the form. You're going to give it to the owner or the owner's architect and the construction lender. Although you can hand deliver these things, express mail, certified mail return receipt requested, as with the other notices, is preferred. And there's the code sections to tell you about this. And if you're going to serve it on a construction lender, you're going to have to serve it on the manager or responsible officer at the branch of the lender where the funds are actually being held. So Bank of America, you're not going to serve their world headquarters. You're going to serve the local branch where the funds are being held. And this is information that the owner and the GC should provide to you. And there is also a code section that says if you request it, the identity of the lender, they're supposed to provide it to you. Okay? And if you're going to serve it on a public project, serve the director, the controller, or the auditor, or a disbursing officer. I've got some misspellings in there, which I'll have to fix for the next time, of the department that awarded the contract. And you can see the code section there if you want to look it up. Next slide. And then serving your stop payment notice. If there's a notice of completion, then a sub or supplier generally only has 30 days from the date of the such a notice before they have to serve this. Okay, and then noted earlier, I noted this earlier, but notices of completion have to be recorded within 15 days after actual completion. If there's a notice of cessation, it's within 30 days. So this is like the Mechanics Lien, where if someone says, oh, hey, there's a notice of completion or notices of cessation, and you're late, then you can't really trust that that notice of completion or notice of cessation is valid, because it might not be within that 15-day window that's referenced there on the middle slide. So, or 30 days if it's a notice of cessation. So you can't trust that. And then I would, just like with the Mechanics Lien, I would just go forward with the stop payment notice. If you're late, then you can always release it. But I would say that, honestly, notices of completion, I'd say half the time, they're not within that 15-day window. And so I say go forward with your stop payment notice. And with public works, you usually don't get into the 15 or 30-day thing, because the notices of completion on public works are generally presumed to be timely. And so you should serve your stop payment notice within 30 days after a notice of completion on a public works project. And of course, that would be for, with public works, the GC doesn't get to serve a stop payment notice, because it would stop money from coming to them, so why would they? But the stop payment notice is generally something that is going to be for subcontractors and suppliers. Okay, next. Okay, and this is the same. How do you determine if a project is done if there's no notice of completion, notice of cessation? Again, you have to look at A, B, or C, as we did on an earlier slide, and then pick the earliest of those. And if there is no notice of completion, notice of cessation at all, then everyone is going to have 90 days after the earliest of A, B, or C before they have to serve their stop payment notice. Okay, next. Well, the lawsuit deadlines. Okay, I would say this, and you can read this whole thing, but the lawsuit has to be served or filed in court no later than 90 days following the expiration of the period of time within which stop payment notices must be served. Now that's a kind of a convoluted equation, but that's what the statute says. And so rather than figuring out, okay, when could it have been served, even if I served it earlier, and then 90 days after that, oh man, that's confusing. So I would say this. I would say it is going to be either you're going to want to do your lawsuit within 180 days after the project was completed, or 120 days from a valid notice of completion. And so I would say, looking at the very bottom of this slide, is the safest practice is to serve a lawsuit to enforce a stop payment notice within 90 days after the stop payment notice was served. Okay, that makes it easier for you, and you're not going to miss a deadline ever. And you can use that same deadline with your mechanics lien, which we discussed earlier, because the deadline truly is 90 days after you record a mechanics lien. You must file your lawsuit. You don't have to wait to the 90th day for sure. You can do it any time in that 90 days. And the same with the stop payment notice. Okay, if you serve a stop payment notice or send a mechanics lien to the county recorder, then 90 days later, file your lawsuit. You should calendar it that way, just to be sure. And for me, I have clients come to me and they will say, hey, I sent out a stop payment notice for recorded lien. I do it like the 80th day. I don't get close to the 90th day because something may go wrong at the courthouse. So they may send it back for some reason. You just don't want to get too close to that deadline. But this is the point where you reach where you're going to have to be talking to an attorney. So, and it's going to take them a little bit of time to get all the information and get into gear. So you probably want to talk to your attorney when you're getting past 50 days at the earliest, or at the latest, I should say, and give them time to get up to speed. Okay, next slide. Okay, the payment bond claim. Okay, you can do these with the mechanics lien. A payment bond is basically a company that has a bond out there that says that I'm going to pay you if you don't get paid. And this is for subcontractors and material suppliers. Now, the preliminary notice, if you're required to serve one, as we discussed before, which would be likely for subs and suppliers, but not necessarily on public works, because it's a little bit different where first-tier subs don't have to serve a preliminary notice. But let's just say you do have to do it. Now, if you forgot to do a preliminary notice, then there's a special rule that can help you. It's somewhat limited, but maybe you just want to do your payment bond claim. And look at this, because you can serve a bond notice within 15 days after a notice of completion. That's a really short period of time. It's a bond notice. And that may get you past the issue of having not done a preliminary notice. And if no notice of completion is recorded, the 15 days is if there's a notice of completion. But if there's no notice of completion recorded and you didn't serve a preliminary notice, then you can serve this payment bond notice within 75 days from the date of completion. But keep in mind that this is limited. It's only used when you forgot to do the preliminary notice and you want to go after the bond. But just remember, there's hope for you, and you may be able to take this route. But the better advice is don't forget to do your preliminary notice at the beginning of the job. Okay, next slide. Okay, you serve the payment bond notice. You're going to serve it like with the others. You're going to serve it by certified mail, express mail, overnight delivery. So these are all the things like UPS, FedEx, this type of thing. You can use those, and the important thing is that you have a record that you did so and it was properly addressed. Okay. If the payment bond lawsuit is recorded, a lawsuit against the bond surety must be filed within 6 months after the notice of completion of the work is recorded. And if it's not recorded, you could have up to 4 years But the longer you wait, the more difficult it is going to be you're going to be able to prove the facts to enforce your rights. Witnesses leave their employers, they go away. It just becomes very difficult. There's no need to wait 4 years. Just get moving on things. Once you file a lawsuit, people tend to pay attention and get moving on things. Okay, let's see what we got in the next slide. Okay, that concludes. So we discussed the preliminary notice, very important. Get that out within 20 days. You have a mechanics lien that you can't do until you're done with your work, and then depends on if there's notice of completion. Once you record your mechanics lien, you have 90 days to file a lawsuit. And then if you do a stop payment notice or payment bond claim, then probably your lawsuit, best, even though you have more time, calendar those out 90 days later, and you should be fine. But don't forget to do your preliminary notice. That is the most important thing. Do it between the time you did the contract to no later than 20 days after you start working on the project. Okay, I went a little bit over. My apologies. And Jesse, are there any questions from anybody?
Well, first of all, Bill, it was well worth it because you gave us some really good information, so I appreciate it. There are a couple of questions that came through. The first one being, when sending a preliminary notice and there is a surety company involved, do you need to send a copy of the preliminary notice to the surety company or list them anywhere on the preliminary notice?
You know, I would send it to them. It isn't part of the statute. It is generally to the owner, the GC, and the lender. But it is probably a good idea to get them on board right from the beginning. There's no prohibition, and I don't think it would harm. So I'd say, yeah, you can, not required, but I think it's probably a good idea.
Okay, wonderful. Another question that came through, it says, can I amend my lien to adjust the amount or correct an entity spelling or something along those lines if I'm still within the deadline, or what about if I'm outside of the deadline?
Okay, so if you're within the deadline, I would say that probably if you have a major change to make, and that's really astute of the person who asked the question about if I'm within the deadline. You could, if you wanted to, you could release your lien entirely and then just record a new one. And maybe that's the best way to go about it, is just to do that. Now, after the period of time, you can amend your lien with a document. I mean, I have one on my computer. I don't know if you at SunRay do these kind of things, but we have sometimes an amendment of mechanics lien, but you can only reduce it down, is my belief in the law. You cannot make it go up, because if you reduce it, no one's going to object if you reduce the amount of lien. And then going up, I think that you would have a problem, and I think that it would be challenged. So I think that that's probably the best route once you're to that point.
Okay.
Yeah. You know, as an attorney, sometimes we have an even, and we get paid, like some money comes in, and then when it's at that point, I just talk to the other attorney and I say, hey, yeah, I see it's $100,000 lien. We just got $25,000 more. Are you going to require us to amend the mechanics lien and amend our lawsuit, or can we just have an understanding between the two of us as attorneys that the actual amount is now $75,000, and then we just exchange emails, and then it just kind of becomes part of our part of the case going forward, that we agreed that the technicality of amending the lien or amending the lawsuit to state a different amount won't be necessary. And that's a good thing between attorneys, because it just helps you to get things resolved at a lower cost, just to mention.
Okay, wonderful. Thank you. Another question that was posed was, if the bond isn't recorded in the county, or you're provided a copy and you can't get a copy of the bond, does the bond claim start once you obtain a copy of the bond? Like the deadline, I guess.
You know, that is the kind of a thing that I would say is why they have such a long statute of limitations. You might remember that I said it could be up to 4 years. Okay, if it's recorded, then it's part of the public record. So you may, it's arguable, but you may have an obligation to go out and find it. But I would say that what you need to do, there are some cases out there that say that if you're not informed about things, or if things are concealed, then you would be given extra time to deal with it because they actively concealed it. So I would say that probably if you have that belief or concern, you should probably make written inquiry to both the owner and the GC as to whether there is any kind of bond out there or anything like that that they didn't inform you about. There are some cases, and also I think a statute might be on point on this. But I think it might apply to the lender, but maybe there's one on the bonds. I'd have to look that up. But I think you start with making an inquiry in writing and see what they say.
Wonderful. All right, I do believe that that's all the questions that have come through. If you have a question that wasn't addressed, please feel free to reach out and we'll be sure to answer those questions for you. Here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Remember, each state has its own unique deadlines, documents, different things going on. So please check it out if you are working in a neighboring state. And it's not specifically California. If maybe you're working in Nevada or Oregon, those states have different deadlines, different document types of what is required. So please check it out to make sure you can best protect yourself. All right, if you don't mind, give us a quick moment of your time. We really do appreciate any feedback you guys can provide to us. It helps us better the material and the content of what we're putting out for you guys, of what you're looking for. All right, and with that, that is all we have for you guys today. Thank you so much to everybody that was able to attend. We hope to see you guys at our next webinar. I know, Bill, you have, I think, 3 other webinars this year coming up later on this year that are going to be wonderful. So please, we'd love to see you guys there. Check it out. Thank you again, Bill. You really are fantastic. And I was not overstating how wonderful you really were. So thank you. And I hope you all have a beautiful, beautiful, wonderful sunny day. Thank you, everyone. Thank you, Bill.
Thank you, everyone. Call me if you have any questions. Thanks.